Good morning, everybody. My name is PRANAV, a legal intern at LEXIS and Company for the month of June. And today I will be discussing about industrial disputes under the Industrial Dispute Act. What is an industrial dispute? An industrial dispute under the Industrial Disputes Act of 1947, and the objective of this act is pointed out in the preamble, that is, to make provision for the investigation and settlement of industrial dispute. Therefore, the definition of industrial dispute has a special significance. The following elements should exist to constitute an industrial dispute. Firstly, a dispute or difference between workmen and employers, employers and workmen, or workmen and workmen. Secondly, the dispute or difference should be connected with employment or non-employment, terms of employment, or conditions of labor of any person. And finally, the dispute may be in relation to any workman or workman or any other person in whom they are interested as a body. Industrial dispute is not restricted to dispute between employer and a recognized majority union alone. It also means a difference between employer and workmen, including a minority union. The definition of industrial dispute does not refer to the term industry, but on the grammar of the expression, it must necessarily be a dispute in an industry. Before an industrial dispute can be raised, there must first be established a relationship of employer and employee associating together, the former following a trade or business in aid of the employer's enterprise. For a dispute to be an industrial dispute, it is necessary that a demand must first be raised to the management and it should be rejected. For coming into existence of an industrial dispute, a written demand is not a sine qua non, unless of course in the case of a public utility service. The term industrial disputes connotes a real and substantial difference, having some element of persistency and continuity till resolved, and likely, if it is not adjusted, to endanger the industrial peace of the undertaking or the community. In Workmen of Hindustan Lever Limited versus Hindustan Lever Limited, the question was whether a demand to confirm employees in an acting capacity in a grade is an industrial dispute. It was held that a demand of the workmen to confirm employees employed in an acting capacity in a grade would unquestionably be an industrial dispute without anything more. In Tirupattur Cooperative Sugar Mills Limited versus S. Shivalingam, the trial court restrained the sugar mill by temporary injunction from implementing the proposed penalty of reduction in rank against the present respondent. The cooperative sugar mills had challenged the said order in the High Court. It was held that the lower court had thoroughly gone into evidence on record and allowed the application for the temporary injunction. The High Court said that there was no irregularity or infirmity in the impugned injunction order. It was made clear that matters of dispute between employer and workmen, other than the discharge, dismissal, retrenchment, or termination of services, are not industrial disputes under Section 2K of the Industrial Disputes Act 1947. What is the difference between an employment and non-employment? The term non-employment includes retrenchment as well as refusal to reinstate. The word non-employment raises questions whether an employee who has been dismissed, removed, discharged, or retrenched can be reinstated by an order of the Industrial Tribunal. In Western India Automobile versus Industrial Tribunal, the federal court held that reinstatement is connected with non-employment and is therefore within the words of the definition. It would be a curious result if the view is taken that though a person is discharged during a dispute is within the definition of the word workman, yet if he raises a dispute about dismissal and reinstatement, it would be outside the words of the definition in connection with employment or non-employment. Now, moving to the next topic, that is dispute relating to workmen employed by a contractor. The Standard Vacuum Company case is a leading case on this point. The Standard Vacuum Company used to give annual contracts for maintenance of plant and premises. In the first year, they employed 67 persons, while the next year only 40 persons were employed. The contractors' men were not entitled to any privileges and there was no security of employment. The workmen raised an industrial dispute demanding the abolition of the contract system. The Supreme Court held that the dispute to be an industrial dispute because there was a real and substantial dispute between the company and the workmen on the question of employment of contract labor for the work and company. The fact that the workmen were employed by the employer would not alter the nature of the dispute so long as the party raising the dispute has a direct interest in the subject matter of the dispute. A dispute about the reason for, for stoppage of work or a dispute relating to application and interpretation of standing orders is also an industrial dispute. When the jurisdiction of civil court is barred. In Rajasthan State Road Transport Corporation and another versus Khadarman, the service of a probationer was terminated. The matter was adjudicated by the civil court, which was challenged on the ground of jurisdiction. The Supreme Court observed that the civil court had no jurisdiction and the decrees passed had no force of law and was set aside. The right remedy in this case would have been raising an industrial dispute under the Industrial Disputes Act 1947. The Supreme Court held that there could be no direction to reinstatement or to continue the reinstatement. Coming to the last topic of under this discussion is individual dispute and industrial dispute. Whether a single workman who is aggrieved by an action of an employer can raise an industrial dispute. Section 2K of the Act speaks of a dispute between employer and workman, that is, the plural form has been used. Before insertion of Section 2A of the Act, an individual dispute could not per se be an industrial dispute, but it could become one if it was taken up by the trade union or a number of workmen. The provision of that act leads to the conclusion that its applicability to an individual dispute, as opposed to dispute involving a group of workmen, is excluded unless it acquires the general characteristics of an industrial dispute. It was held in Jagdish Narain Sharma and another versus Rajasthan Patrika Limited and another that a dispute relating to transfer of a workman will become an industrial dispute only when it is espoused by a union of workmen or by a substantial number of workmen employed in an industry. Without such espousal, the dispute cannot be treated as an industrial dispute and cannot be referred to a labor court. Section 2A is of a limited application. It does not declare all individual disputes to be an industrial dispute. A dispute connected with a discharge, retrenched, dismissed, or terminated workman shall be an industrial dispute. Thus, only a collective dispute would constitute an industrial dispute, but a collective dispute does not mean a dispute that should either be sponsored or recognized by a trade union or that all the majority of workmen of an industrial establishment should be parties to it. Where an industrial dispute is espoused by the union, the question of the employee being a member of the union when the cause arose is immaterial. But even if there is a continuity of interest between workman and a person who is not a workman, the question of employment of the latter cannot form the subject matter of an industrial dispute. In order to make a dispute industrial, it is not necessary that there should be a resolution of substantial or appreciable number of workmen. A maximum number of 18% employees, including the dismissed employees, supporting the individual dispute were considered not sufficient to convert it into an industrial dispute. With this, I come to the end for today's discussion. Thank you all.